Our next topic is, again, listening to a special guest. Is he there now?
Yes, yes.
Well, I'm referring to Dr. Laurent Bartels from the University of Cambridge, who will present us this publication, which was researched and written by him. Well, let me tell you that Dr. Bartels is very well known when it comes to researching and publishing on relationship between labor rights, human rights, and trade and investment. He has an extensive literature on these topics, and I welcome his latest work, European Parliament's role in relation to human rights in trade and investment agreements. As you might know, human rights clauses have been included in international agreements of the Union, trade agreements and other agreements since now almost 20 years, since 95 at least. So there is now a huge number of human rights clauses in EU trade agreements, and we are only referring to trade agreements, not other agreements. Article 21 of the Treaty of the European Union, after the Lisbon Treaty, brought not only a legal basis to these human rights clauses, but also sort of a mandatory obligation for the Union to care for human rights in all our external action, and this includes, of course, trade. That's why this study is very much welcome when we are heading for the end of this first term of the European Parliament after the entry into force of the Lisbon Treaty. Dr. Bartels, welcome to this committee. You have the floor to present your study. Thank you very much.
Thank you, Chair, for that very kind introduction. And I'd like to begin by expressing my gratitude for the invitation, first of all, to write the study and also to come here and present it to you. It's indeed a great honour, particularly because as an academic, one always wants one's work to have an impact in the real world. And this is a great opportunity, I hope, that to some extent this does. As you said, Chair, the study is about human rights clauses, which have been in the EU's trade agreements for around 20 years now. And what the study looks at is, firstly, how these human rights clauses can be improved and should be improved, particularly in light of recent developments and the experience of having these clauses in agreements over 20 years. They haven't changed a great deal in that time. And secondly, and importantly, what is the role of the European Parliament in achieving the objective of improving the nature of human rights clauses and their monitoring, enforcement, implementation, particularly in light of the new powers that the Parliament possesses after the Lisbon Treaty. Now, I should begin by saying that, of course, human rights clauses are not the only game in town. As I'm sure members will be aware, there is a wide variety of conditionality provisions in the EU's external action, which ranges from conditionality provisions in the Generalised System of Preferences regulation, and when it comes to agreements, also sustainable development provisions in trade agreements, and in particular when it comes to the labour provisions in the sustainable development chapter that is now, since 2008, in the EU's trade agreements. There is a great overlap with the human rights clause, given that fundamental labour rights are, of course, also fundamental human rights. So there are overlaps, but I'm focusing in this study just on the human rights clause. So I thought I'd better begin just with a brief refresher on what the human rights clause actually is. And for those of you who have the study in front of you, on page 8 there is a quotation at the bottom of the page which sets out the fundamental obligation, which is known as the essential elements clause. It's found in usually Article 1 or Article 2 of every trade agreement, or every cooperation agreement. I'll just read it out, it's not very long. It says this: respect for democratic principles and fundamental human rights as laid down in the Universal Declaration of Human Rights and for the principle of the rule of law underpins the internal and international policies of both parties and constitutes an essential element of this agreement. So it's fairly strong stuff. Now, that's the essential elements clause. The second clause, which I have summarized a little bit, but I'll just tell you what this is the way that this clause is enforced. And this is by way of what is called a non-execution clause or a non-fulfillment clause. And what this clause essentially says is that either side is entitled to adopt appropriate measures in the event that the other side violates the essential elements clause. So you have here a tough obligation to respect human rights in domestic policies and in international policies, and this is backed up by the possibility of the other side adopting appropriate measures in case you don't do that. So I've, in this study, arrived at 11 recommendations, which are on pages 22 and 23. They're not numbered in this report. They will be in a later version of the report, but it doesn't make much difference. Each paragraph corresponds to a recommendation. I'm just going to run through the main recommendations with a little bit of a commentary where necessary. So the first two recommendations are to do with the coverage of the clause. Since 1995, the Council in 1995, the Council adopted a formal policy that the clause would be included in all future trade agreements and in cooperation agreements. Now, this policy was revised in 2009, so now it is sufficient that the clause be included in what are called framework cooperation agreements, but no longer in trade agreements. So the first question that I address in the report is whether this is good enough. There's an obvious political reason for doing this, which is when you're negotiating with a country that doesn't particularly want to have human rights in a trade agreement, it's now possible to say to that country, don't worry, it won't be in the trade agreement, it will be in a cooperation agreement. So the question is, does that weaken the application of the clause? It's a significant change in policy. My conclusion, having looked at this, is that it doesn't weaken the clause in almost all cases. And this is for two reasons. Firstly, there is usually a linkage clause, sometimes known as a passerelle, which is in the trade agreement, which links to a human rights clause in the cooperation agreement. A good version of this is in the CARIFORUM Economic Partnership Agreement, which links to the human rights clause in the Cotonou Agreement. And that locks it in. No? It says that the human rights clause still applies to the trade agreement. But this is done much more weakly in other cases, for instance, the Singapore Agreement, the Korea Agreement, where it's doubtful whether the linkage clause actually works at all. The second conclusion is that it actually doesn't matter, because when the human rights clause in a cooperation agreement provides for appropriate measures, those appropriate measures entitle the EU, I'll just use obviously it's bilateral, but I'll refer to the EU, seeing as where we are. It is still possible for the EU to adopt appropriate measures in the form of suspending any other obligations owed to that party, no matter where those obligations are, including in a trade agreement. There is a qualification to this, and that is that it only works by definition when the human rights clause provides for appropriate measures. Now, in all agreements since late 1993, human rights clauses have provided for appropriate measures. But there are three old cooperation agreements which are in a form which doesn't include appropriate measures. And here, this linkage, this connection of trade agreement to cooperation agreement would need to be looked at very closely, because it's not automatic in the way that the linkage would be when there are appropriate measures. These three countries which have these agreements with the EU are India, Mongolia and Sri Lanka. Now, of course, everybody here will be well aware of the forthcoming EU-India free trade agreement, or at least the negotiations in this direction. So one of my recommendations here is that Parliament should look very closely at the linkage clause in any EU-India free trade agreement to make sure that it allows for the adoption of a proper human rights clause, appropriate measures regime. It can't be taken for granted, and of course it's no secret that the Indians are not particularly keen on a human rights clause. That's one, I'd say, a red flag. In all other cases, including recent agreements with recent association agreements, recent agreements which are on foot with Canada, and so on, it seems that the policy is intact, and provided that the standard wording of the clause continues, and there's no reason to believe that it wouldn't, there is no reason to be worried about the potential coverage. But it's something that Parliament should keep an eye on, particularly given the relatively strong bargaining position of those countries which are currently negotiating agreements with the EU. So that's to do with coverage. The next set of recommendations have to do with the obligation to comply with human rights and democratic principles, the standards of human rights protection and protection of democratic principles. Now, the main point here is that the Essential Elements Clause is basically quite good. No? It's held up fairly well. It's very comprehensive. I know that from time to time the Parliament has made resolutions saying we should put in something specific about this human right or that human right or so on. My view on this is that, in general, the clause is fairly robust and is broad enough to cover a wide variety of human rights, virtually all human rights and democratic principles. However, it can be fixed up, not in the sense that one would, in my view, want to insert specific human rights in there, but rather it should be updated to allow for the possibility that the EU and its partners become subject to new human rights obligations in the future, and the clause should should incorporate any new human rights obligations of that sort. To this end, I am very much in favour, and I recommend that the wording of future human rights clauses be changed to match the clause in the Korea Agreement, which adds a reference not only to human rights and democratic principles as set out in the Universal Declaration of Human Rights, but also it says, and in other international instruments. And that is a sort of future-proofing drafting, which I think would be wise to include in future human rights clauses. Another proposal that has been made by the Parliament in the past is to enhance the Essential Elements Clause by building in specific benchmarks for human rights performance with a given country. My view is that it's probably inappropriate to have specific benchmarks in a framework agreement, but there is certainly no reason why one could not have specific benchmarks targeted to a country's performance on a given date with a timeline and so on in a side agreement, and that side agreement, compliance with the obligations in that side agreement, are then incorporated into the human rights clause. That allows for a degree of flexibility, but essentially this is a question of drafting. Another recommendation is on enhancing the Essential Elements Clause to provide for references to corporate social responsibility. Now, I discussed this at some length in the report, and my conclusions are that indeed this is a point which could be enhanced, perhaps not in the Human Rights Clause itself. Perhaps it's more appropriate to have a separate clause on corporate social responsibility. And I analysed what this can actually achieve, and in fact, my conclusions are that a provision on corporate social responsibility can achieve three things. Firstly, it can be useful for its own sake. Right? It can encourage a partner country to adopt itself corporate social responsibility norms, and that can't be a bad thing. Secondly, the function of a corporate social responsibility clause could be more practical and can aid in the objective of ensuring that the EU's own corporate social responsibility interests, its own corporate social responsibility obligations and so on, do not lead to the EU's economic position being undermined by third countries. So this is the creation of a level playing field, to put it in those terms. And that is certainly one of the important functions of a corporate social responsibility clause that should not be underestimated. The third is a little bit arcane, maybe, and comes from the literature on these clauses. It's sometimes suggested that a corporate social responsibility clause could have the effect of rebalancing, or indeed balancing an investor's obligations with the obligations of a host country. I go into this in some detail in the report, and my conclusion is that this objective would not be achieved on any of the standard corporate social responsibility clauses. It's in terms of how the norms are addressed to certain actors and so on. And I didn't have time in this report to give a proposal on how such a clause might look if that were of interest, but it's certainly something that could be done. It just requires a little bit of further work. But I gather that this isn't the main interest of the Parliament and this committee and the Parliament anyway, so this is also why I didn't spend so much time on this. The third area is to do with monitoring of the human rights obligations, including the new ones which I've just talked about. Now here, my major recommendation is that every agreement that includes a human rights clause should also provide for a human rights committee. Now, it's notable that the EU's trade agreements themselves set up many committees on SPS, on customs valuation, on rules of origin. They're replete with committees in the agreement, in addition to the committees which can be established later on ad hoc by the Joint Council in the agreement. But there has never been a standing human rights committee, and I think this counts as an anomaly, a gap. And given the importance of human rights in trade agreements, it seems to me fairly straightforward to make the recommendation that a human rights committee should be a standing item in every future trade agreement. What this committee should do, I would say, I wouldn't go so far as to say it should have any decision-making powers, but I would say it should have recommendatory powers. It should have a mandate to focus on the implementation of the parties' obligations under the Human Rights Clause. And in particular, any situations in which the implementation of the agreement itself, which is to say its trade or investment or intellectual property obligations, are having a negative impact on human rights, either at home or abroad. So a monitoring role I would foresee for such a human rights committee with recommendatory powers to the Council to take action. Now, a second recommendation along these lines, which is monitoring, this is drawn from the new GSP regulation, the possibility that the Commission or the EEAS report to the Parliament on a biennial basis on the implementation of the Human Rights Clause in these agreements. The fourth area of recommendations are to do with the enforcement of the Human Rights Clause. Now, here, the current system is that the enforcement of these clauses is left entirely up to the Council on a Commission proposal. The Parliament has no role, nor does civil society, nor do individuals. I don't make any recommendations to change the final say on the enforcement of human rights clauses, but my recommendation here is that a lot can be done before that decision is made, and specifically I recommend that a regulation be adopted under the ordinary legislative procedure, and I analyse in the report that whether this can be done, and my conclusion is it can be done legally, that a regulation be adopted under which a trigger mechanism is established providing for the Parliament, other EU institutions, or civil society or individuals to request at least that an investigation be launched by the Commission or the EEAS into potential or alleged human rights violations. Of course, once an investigation is launched, it is more likely that a human rights clause will be enforced. A brief side note on the history of enforcement of human rights clauses. They have been enforced 23 times in the last 20 years. Every single one of those occasions has involved a situation of serious political instability in an ACP country. From the Council point of view, the human rights clause is these days not considered to be a human rights clause, it's considered to be a political clause. And it is significant that the 2009 document which set out the Council's new policy on human rights clauses wasn't entitled human rights clauses, it was entitled political clauses. Now, of course, in many cases there are overlaps between human rights violations and situations of political instability. But it goes without saying that the second is a subset at best of the first. And the practice shows that the human rights clause is not being used to its full advantage. Having a regulation which allows for the commencement of an investigation triggered by other EU institutions or by individuals is likely to enhance the enforcement of the clause. And this proposal doesn't come out of thin air. This proposal is adapted from the model of the United States and Canada and Chile examples. In their free trade agreements, ever since NAFTA, Mexico in NAFTA but not since then, these countries have always included the possibility of individual enforcement of what in that case is labour standards. And there have been many cases, 47 cases in fact, in which these investigations have been launched and have led to action by the executive. So my proposal is based on the practice of our friends across the water. The fifth category of recommendation is to do with implementation. Now, I separate this from enforcement for this reason. Enforcement is broad. The origins of the Human Rights Clause, which you can read about in the report briefly in the beginning, the origins of the Human Rights Clause are that the clause is seen in part as a sanctions clause, where the human rights violations don't have much to do with the agreement in which the Human Rights Clause is found. However, with trade agreements, it's obvious that in certain cases, extreme cases, I mean, I speak as someone whose life is in trade more than in human rights, so I by no means think that trade always or even often leads to human rights violations, but of course there are extreme cases in which trade obligations themselves can lead to human rights problems. This is well known, or at least allegations to this effect are well known. This is what I refer to by implementation, the implementation of a trade agreement, the obligations in a trade agreement, water services liberalisation, intellectual property protections and so on. When the implementation of the obligations in a trade agreement themselves lead to human rights violations, then there is a problem, and there is particularly a problem under the Human Rights Clause, which is in these agreements. So I make two main recommendations to do with this subset of cases. No? So not just misbehaviour by the other party, but rather a situation where the obligations themselves in an agreement lead to human rights problems, for which the other party might not even be responsible. And as the chair of this committee so appropriately said in his introductory remarks, under Article 21 of the Treaty on European Union, the EU itself has an obligation to make sure that there are not human rights violations in third countries as a result of its own policies, which include trade policies. So this is a matter of the EU's own interests. It's not a question of violations by the other party. So my two recommendations here are, firstly, a bilateral action that the Joint Council in a trade agreement should have the power, and it doesn't always have the power, sometimes the powers of these councils are limited, should have the power to suspend obligations in the agreement when it is clear that these obligations are leading to human rights problems in a party to the agreement. This is not always there. It is in some agreements, the CARIFORUM agreement, for instance, not all agreements. And the second the second recommendation on this point, which is the final 11th recommendation that I make, is there should be a new clause in trade agreements. And this clause should provide for the unilateral suspension, or rather, let's put it this way, should provide for an exception for unilateral action by a party to the agreement to adopt measures that are necessary for its compliance with its obligations under the Human Rights Clause. Now, this may seem radical, but I'll just take a moment to explain why it's not. You will all be familiar, I'm sure, with general exceptions in trade agreements. These originate, they originate in a US-Mexico agreement in the 1930s, but they're most famously in Article 20 of the GATT and in Article 36 of the Treaty on the Functioning of the European Union, which allows the parties to adopt measures that are necessary to protect human health, animal health, life, public morals, protect the environment, etc., etc. My proposal here, my 11th recommendation, is that a new line should be added to these general exceptions. The new line should simply say, measures necessary to comply with human rights obligations under the Essential Elements Clause, or, more broadly, measures necessary to comply with human rights. Why is this not so radical? Because there are restrictions on the exercise of any such rights built into the general exceptions clauses which prevent abuse. No? Any such measures may not be arbitrary or unjustifiable, may not lead to arbitrary or unjustifiable discrimination, or be a disguised restriction on international trade, and so on. These are well understood by trade lawyers. There has not, and this is my area, there has not been any allegation that these clauses have been abused at the international level. I can't see any reason why a clause would be abused at the bilateral level, simply because it is possible to adopt a measure that allows a party to comply with its human rights obligations. And I would say that, in particular in light of Article 21 of the Treaty on European Union, this clause is something that the EU should really include in its agreements. So, some final points. What is it that the European Parliament can and should do about this? Well, this comes in a number of different forms. The first thing to say is that, of course, the Parliament now has a consent power over trade agreements, and that puts it in an extremely strong position, and the Parliament has exercised this power, as everybody knows, in the example of the safeguards regulation following on from the Korea Agreement. So the Parliament, if it chooses to, can exercise its consent power to force a redraft of the clauses themselves, and many of my recommendations are to do with and require a redrafting of the clause. This can be done if the Parliament wants to do it. Should this not be feasible or desired, there is a softer option. The regulation that I mentioned before, the regulation which would enable an individual trigger, which could be by an EU institution or by an individual, a trade union, civil society, whatever it might be. That regulation can be adopted under the ordinary legislative procedure. There is a question. Does the EU have competence to do this? Does this interfere with what is often seen as a sole right of the Council under the treaty-making and suspension powers set out in the Treaty on the Functioning of the European Union in Article 218.9. Would such a regulation interfere with this? My conclusion is no, not at all. This is perfectly feasible. The final point, the Parliament can use its consent power prior to the conclusion of an agreement to require improvements in human rights performance by a third country. Of course, the problem with that is that as soon as the agreement is concluded, the Parliament at this stage loses its power. And to that extent, the Human Rights Clause operates to neutralise the powers of the European Parliament. And that is why this exercise of the consent power works up to a point, but really needs to work alongside a redraft of the clause and, in my view, an adoption of a regulation that would bring the Parliament back into the implementation and the enforcement of the Human Rights Clause, which is where I think it should be. So thank you very much. I look forward to any questions.
Thank you very much indeed for your clear and very structured presentation of your study, particularly about recommendations. Let's open the floor to questions. First one being William Dartmouth. Sorry.
Sorry, am I ready?
No. Sorry. Campbell Bannerman. You have priority because I didn't see my record, so I do apologize to you, William Dartmouth.
Thank you. Dr. Bartels, it's good to see someone from the University of Cambridge here. I represent Cambridge, and of course it is the best university in the world. Well, I'm biased.
Save mine.
Said I. I'm now going to, though I am very concerned about some of the elements of your conclusions, though, because the feedback I've had from a lot of ambassadors is that there's increasing concern about human rights clauses being imposed on them through these agreements. And it's clearly, you talked about ACP countries actually violating these things, but you're talking about quite advanced countries like Canada, where the agreement has been slowed up significantly. Japan has said that they're worried about capital punishment as an element of trade talks. New Zealand is worried about losing all their agreements if they're seen to break human rights clauses. So I do have a real worry about this, because my feeling is, and I keep saying this on this committee, shouldn't trade agreements be about trade? Shouldn't they be about jobs, investment, the economy? And aren't we really in danger of actually getting distracted? I'm not saying human rights is not, obviously it's a very valid thing, we all believe in that, but there's a real danger, I fear, that if you're suggesting here you're actually tightening the criteria on human rights being applied, like your committee. My fear is you're not going to get any trade agreements at this rate. You're going to actually, they're going to get longer and longer. I mean, India's 7 years now. TTIP could take 6 or 7 years, I hear. Do you want them 10 years? We weren't going to get any trade agreements. And so my suggestion is, I'm very concerned about this, and some of these are almost neo-imperialist as well. Why is the EU trying to dictate to these countries what its own government should be looking at? Surely it's for the government, their governments, to look at human rights issues. And I have to say that, the situation in Ukraine, and I know Ukraine well, I've been to Crimea, I've been around the Russian fleet in Crimea, part of that was because of the geopolitical damage caused by pushing trade and, well, beyond trade, the human rights aspects, political aspects, and look at how Russia's reacted to that. I think it's actually quite dangerous. Can we please just not get back to trade and getting people jobs in Europe? Thank you.
Yeah, well, I was very interested by your submission. I have to say, is to declare us a reverse interest as a graduate of Oxford University. It just is interesting just hear just how out of touch Cambridge University really is. One does hear that. I just put it to you that, and I've heard from our distinguished chairman over the last 5 years several times, put with his customary precision and clarity, that there is a human rights clauses in the Lisbon Treaty, and that therefore legitimizes everything. But I wonder if it's ever occurred to you that these human rights clauses was put there as a little bit of a declaration of intent, and wasn't really meant to be contractually binding, and that if people had really thought that a Cambridge academic was going to come on and saying every single dot and comma of the Declaration of Intent has got to pervade every single trade treaty from now on in, they might not have just signed up to it with quite quite the same enthusiasm which they did. As a clever fellow, I just wonder if you might just want to consider that in the light of your very detailed recommendations. There's two other points, which is, you said, the Parliament must do this, the Parliament must do that. Well, the Parliament, although we think it's not a democratic body, is a representative body. And the current political makeup of the Parliament is not frozen as it currently is in perpetuity. And one of the things is that I think that you'll find that after the May elections, the new Parliament, which comes in July the 1st, will have a materially different makeup from that which it does now. So you might not be so content with the Parliament, the Parliament, the Parliament. The other thing which I'd like to ask you is a specific question, and it's on your page 23D. You've got this phrase here, representatives of civil society. What is it that they're allowed to do? Yes, a mechanism according to which are able to make requests, and the Commission is obliged to do what they follow. Well, representatives of civil society, as you will have known, our great British parliamentarian, Tony Benn, died last week. And he was a great one for representatives of civil society, by which he really meant trade union delegates and nobody else should be represented. Now, can you fill out exactly what you mean by representatives of civil society? I mean, it's a bit of a vague term, or rather, I think it you mean just delegates of self-appointed institutions. And then the other point which I leave you with which and this will be my final word, which actually echoes what my distinguished colleague to my right, although he'd hate to place himself there, thinks, is that I've just looked in your very useful glossary here, and we have here that in the course of this Parliament we've actually signed agreements with Tajikistan, Turkmenistan, Iraq, and various countries in Central America that would be sort of OTOs to go into. Well, on the basis of what you're putting forward, none of this would have happened. And further, negotiations are anticipated with China, Belarus, Iran, Syria. Well, none of them are going to happen. And there's ongoing negotiations with Azerbaijan and Kazakhstan. Well, all these would have to just go into fast retreat if any of this was implemented. Now, if you take the proposition that free trade agreements are basically a good thing for the European economies and a good thing for the people of Europe, you're basically putting a series of massive roadblocks against any of these, against future trade agreements coming into being. And I'll leave you with one final sentence. I think I detected a hint of an Antipodean accent.
Yes, I'm sorry about that.
I'm married to an Australian.
Anti-what?
What?
Anti-what?
Southern Hemisphere. Southern Hemisphere accent. My wife is Australian, so the point is I say this in admiration and no other way. And I just make the point to you that New Zealand, it's just a question of fact, New Zealand has got a trade agreement with China. The European Union doesn't have a trade agreement with China. And what you're suggesting will make it very nearly impossible for the European Union ever to have a trade agreement with China, if that is deemed to be desirable in economic terms.
Well, this is not a British debate, of course. But since you mentioned Tony Benn, let me pay tribute to him, because I was there in my London years. Tony Benn was very active in Labour Party. So I owe very much to him. David Martin, floor is yours.
Well, I wanted to thank the Speaker, firstly, for a very interesting presentation. And contrary to my two British colleagues, I take the opposite view. I think human rights is an essential element of all our trade agreements. And I was more interested in how we make the human rights clauses work, rather than the principle of whether they should be in the agreements or not. And I think your 3 points on monitoring, enforcement and implementation were 3 points I was particularly interested in, because I personally think this Parliament puts, rightly, a lot of effort into ensuring that we get human rights clauses in our trade agreements. but we do not do very well in terms of monitoring those clauses once the deals are up and running, and we need to improve our practice of monitoring. Now, we are starting to do that a bit with Colombia, and I'm not on it, but there's a delegation going to Colombia next week to see how the human rights roadmap is working in relation to Colombia, and that's very positive. But the truth is, even if we improve our monitoring, it takes us on to the second point, the enforcement is almost impossible at the moment. We have, sticking with the same country just as an illustration, I mean, we did fight for about 7 years to get the Commission to open an investigation into Colombia in relation to GSP Plus and a breach of human rights, and the Commission always said they didn't have complaints that fell within the criteria. So I think something along the lines of the US model is worth considering, but I would like to ask the Speaker if he's done any assessment of how well the US system is working, because on paper it looks better than ours, but I'm not sure actually that it's led to much more action than the EU system has led to. And finally, on implementation, I think I have some idea of the examples he had in mind, but I would be quite interested in examples of where obligations under a free trade agreement could actually lead to breaches of human rights. If he has any specific illustrations of that, it would be useful to hear. But I think I was already on this line anyway, but I think it's very important that he has reinforced our view that human rights are an essential part of our trade agreements, and the issue is not whether they should be there, but how we make them work within those agreements.
Thank you, David. Helmut Scholz, GUE.
Thank you, Chair. I also want to thank also this very, as you said, structural briefing on the study. And I agree very much with certain proposals he made, maybe also contradicting to my British colleagues here, which maybe is not astonishing. But I would like to come back to some general aspects, because we have not an academic exchange of views on the human rights, but we are politicians and we have to link it to our responsibility to include this debate in practical steps towards the accompanying of future trade agreements and our work here to accompany the acting of the Council and of the Commission. And therefore I would have 3 or 4 questions to the Commission, probably also listening very accurately to this report or to the speech of Mr. Bartels. So let me come back to the essential elements clause. The EU enshrines this clause in all its external agreements since 1995. And so just now we have on the table or on the paper the proposal to broaden up this clause, not only from the Universal Declaration of Human Rights, but to other relevant international human rights instruments. And as we are aware about the discussion in the UNHCR and Human Rights Council in Geneva on finding the chance for a universal transnational cooperation, human rights obligatory mechanism and international treaty on that, I would ask you if you would agree with this proposal by the author, and so to enlarge the essential elements clause in agreements and to modernize it in future. So what we are addressing in this, or what we are will face in this regard in the next proposals, agreements you put on the table, for example, the Mexico agreement, which we will later discuss. Secondly, only the Commission can trigger the human rights clause by a proposal for action for the Council. And that means that the Council can decide to take appropriate measures. But what does it mean, this can? Is it obligatory? Is it by animosity? Is it by majority, etc.? So what does it mean in concrete from your point of view? And who defines what is an appropriate measure? And finally, in that relationship, I would be interested if the Commission is ready to set up really, in reality, permanent committees on human rights clauses, as it was also defined. which would be different from the existing dialogues, and which additional competences they should have. I can understand what Lord Dartmouth just what he explained on the question of human rights and the ability to conclude concrete trade agreements. But if we are speaking, for example, about the fate in Bangladesh, of the fate of textile workers, etc., that is directly affecting not only them, but also the producers in our market. So the question with a trade agreement is, of course, linked to the ability to discuss how we want to produce, how we want to consume, on which conditions, and what does it mean in obligatory issues in the trade agreement. One question to Mr. Bartels, having read the study, you refer to this domestic advisory group, and you state that this, in the comparison between the trade agreement on Colombia and Peru and the clause introduced there, that they have less status and power than those conditions inherent in the Korea agreement. What do you mean exactly? And can you explain a little bit more this question? Because I think that it's important for us as parliamentarians for the future work on accompanying the trade agreement. Thank you very much.
Thank you very much. Before listening to the Commission, let me also come with a couple of remarks. First of all, let me tell you that I announced this already in the morning, that my next book will be on the labor clause on the trade policy of the Union. That's why I think most of the writings of Dr. Bartels. And there is also a chapter on the human rights clause in not only in trade agreements but also in the GSP plus scheme of union. Needless to say that, of course, I concur with this idea of enhancing the human rights clause, no doubt about it. But let me play the devil's role and make some considerations as if I were against it. First of all, is it feasible to achieve this enhancement of the human rights clause? Because apparently the external human rights policy is part of the common foreign policy, not part of trade policy. Therefore, it belongs to the Council for its definition, shaping, and conduction under unanimity rule. Is there any hope that the Council will deliver on this? Will agree with this approach and to bring about such an enhancement and strengthening of human rights clause in trade agreements? Secondly, resistance of our trading partners. We know that, for example, Australia just refused to negotiate a trade agreement with us because of the human rights clause and the other political dimensions of the democracy clause. Not, of course, because they are not willing to respect human rights, but because they feel that it is an attack on their sovereignty, or it is just pretentious of the European Union just to try and patronize Australia when it comes to human rights. So will we be able to sell to Australia or to any similar country an enhanced version of something that they have already shown not to agree on? So this is about feasibility. Secondly, is it advantageous to have such a strengthened, enhanced human rights clause? because the inclusion of human rights clauses in trade agreements makes of them mixed agreements. Therefore, trade agreement will cease to be the expression of an exclusive competence of the Union, decided by this Parliament and by the Council, under majority vote in Council. It will become a matter for the Member States, under a veto power from any Parliament or any government of the Union. Rather than have a majority here and a majority in Council, we would need unanimity of the governments and parliaments of the 28 member states, maybe 30 plus, in the near future. Is this advantageous to the Union? To have the trade policy made hostage of the veto power of any one single parliament or government in the Union? Of course, this risk exists already. No doubt about it. And we are living with it so far. But wouldn't the idea of an enhancement of the Human Rights Clause enhance also the possibility of this veto power being exercised against the exclusive competence of the Union? On enforcement of human rights clauses. According to the treaty, only the Council is competent to suspend any international agreement. So when it comes to enforce the obligations enshrined in an international agreement, not this Parliament, not the Commission, only the Council will be able to decide. So in any event, we would always be dependent on the Council. Of course, the treaty might be changed. But you cannot rely on treaty changes, can we? So we should count on what we have, the treaty as it is there. Of course, we could put pressure on the, as we can now, put pressure on the Council to suspend the obligations of the Union vis-à-vis any trading partner because of breach of human rights clause. But in the end, it depends on the Council. So I think that we have some limits here that, however positive and desirable, and I could only second you in this regard, we can be about the human rights clause, I see some difficulties in getting it achieved. This said Commission, Mr. Nikos Tsaimis.
Yes, Chairman, thank you very much. First of all, I would like to thank Laurent Bartels for his study. Laurent Bartels is quite well known in the academic community, and he has started as a trade expert. He has written extensively on trade and human rights, so whatever he writes, of course, we're taking very seriously. In terms of the Cambridge aspect, I have to say I did a summer course in Cambridge. I don't know if that makes me qualify as a Cambridge, but I should add that I did study at the University of Exeter, so that makes me sort of a competitor, I understand. Nevertheless, I will try to present briefly a few of Commission's comments on these. I would actually tag it as a sort of an academic discussion. You know, it's like a brainstorming, and I was also very interested in listening to the observations of the members of the committee and of the chairman. Now, the study, and I want to remind everybody again, this is a study. We don't have any, it's not a resolution, not yet at least, has done a very good job in describing the state of play of the human rights clause in trade and investment agreements. It has done a very good job in discussing ways to improve that clause. It has discussed the role of the European Parliament and finally has given us certain recommendations that Laurent has just developed for us. Now, I will not at all discuss the chapter on the role of the European Parliament for obvious reasons. On the general recommendations, I think that the gist of the analysis is that the human rights clause is part of the picture, has been part of the picture for the last 20 years. And in that sense, I would like to underline, especially with regards to some comments made by certain members, that human rights is part of commercial policy. It is an obligation to be taken into account in all external aspects of EU. For it is part of the picture and part of the framework. Now, it has developed over the last 20 years, of course, and nobody will argue that it is a perfect clause. It has developed over time, and indeed there is room for improvement. Now, with regards to certain recommendations, I have to say personally I find some of them very interesting. I was interested specifically on the point about the need to pay attention to the cooperation agreements with India, Sri Lanka and Mongolia. Indeed, we are negotiating with India now, so this is a very critical observation that we will look very seriously into it. Also, the suggestion that perhaps the Korea FTA clause, it is perhaps better drafted than clauses in other agreements. Obviously, I need to remind everybody, and I think the chairman has already done that these are negotiated clauses. They're not imposed in the same sense as we have the liberty of, imposing our own conditions in unilateral preferences, like the system, or the GSP system mentioned earlier. They are negotiated, therefore the trade partner has to agree to them. They have to agree to the specific language. They have to sign and ratify the specific language. The second point is that they are reciprocal. We cannot, of course, request that the human rights clauses is imposed somehow on the other partner and applies only on the other partner. And that's why some of the recommendations perhaps could be problematic. And I will mention one, for an example, the issue of the benchmarks. Laurent did mention that it would be a good idea perhaps to have a list of benchmarks somehow to be able to test or measure the human rights clause, not in the agreement itself, but in an annex. Of course, that would imply that we will be ready to accept such a benchmark on our own human rights situation within the EU, and I'm not sure we are there. Also, other recommendations like on the CSR, we would have certain difficulties. There is a suggestion perhaps to make it more mandatory. It's not the time now to discuss, the technical aspects, but again there we have we may have some issues, as the very nature of CSR is that they are voluntary, of course. Now, on the suggestion to have a mechanism for civil society to bring complaints under the agreements. This borrows from the language that exists in the GSP regulation. Indeed, under the reformed GSP, there is a greater role given to civil society, social partners, member states and the European Parliament, and that's expressly stated in the text of the regulation. Whether, however, we can transpose language that we have chosen, from a unilateral into a bilateral agreement, this remains to be seen. What I want to say is that the absence, perhaps, of specific reference, the absence of a regulation giving specific rights to private parties, has not stopped private parties from bringing complaints. And I would like to remind the committee that in the two cases where we have withdrawn GSP preferences in the past, and that relates to Burma, Myanmar, and Belarus, both cases were initiated on the basis of complaints brought by trade unions. So sometimes the absence of specific language does not prevent civil society from bringing us information and us acting on it. Now, on overall, I think the question that needs to be asked, perhaps, is the human rights clause effective? There, I think the author has replied already himself, saying that it can be improved, it is effective. I did read also some of the papers he has written in the past, and as I said, he has written extensively. And he himself, in a recent paper around in November 2013, on human rights and sustainable development obligations in EU free trade agreements, you did answer that question on whether these mechanisms are effective, and I'm just reading that in the case of the EU's obligations with respect to human rights and democratic principles, the answer is that despite certain infelicities in wording, the human rights clause is sufficiently robust and flexible to enable the EU to ensure that it can withdraw from any commitment that would imperil its obligation to respect human rights and democratic principles in its external relations. And I share that comment. I also wanted to, should have said earlier, add an example mentioned by the author was that this has been used, the clause, in 23 cases, all relating to ACP countries. I will bring one more example showing that the EU can be creative when it comes to defending human rights or invoking human rights with a view to suspending trade agreements, and that was the case in the suspension of certain chapters of the bilateral agreement with Syria. That agreement had been signed in 1977, so it predated, I would say, all these developments that we just discussed of the last 20 years. But it did say in the preamble there was a statement that the parties want to demonstrate their common desire to maintain and strengthen friendly relations in accordance with the principles of the United Nations Charter. And that was it in the preamble, and I think that was enough as a hook, as we would say, for the EU to act and consider that the circumstances in Syria were a clear violation of the principles of the United Nations Charter, which constitute the basis of the cooperation between Syria and the Union. Now, before perhaps concluding, I wanted to say also that the chairman at the end raised some very interesting questions about to what extent these clauses can be improved, modernized, expanded without threatening the flexibility, of entering into a free trade agreement, something that also the first member asked. Very good point. I would not pretend to have an answer. I think that this study basically raises some fundamental questions. We should be able to look at ourselves in the mirror. We consider it food for thought. And of course, it's food for thought for all of us. We don't know to what extent some of these recommendations may or may not be adopted in the future by a future parliament. That remains to be seen. But certainly it is a very good effort. And on the last question that I think one member raised on whether the Commission will be ready to establish specific committees, as I said, these issues need to be negotiated every time with trade partners. But I want to point out already that the joint committees, association councils under these agreements normally can discuss all issues under the agreements, therefore human rights issues as well. With that, I would like to conclude and remain available for, of course, further questions or discussion. Thank you.
Dr. Bartels, I forgot one provocation. TTIP. Will the United States ever agree on a human rights clause in TTIP?
Thank you very much, everybody, for a really rich set of observations, criticisms, comments, and so on. It's very satisfying to me to know that something that I've done has provoked these thoughts. I did want to be systematic, but I think it's probably better if I just go through the various points sequentially, and of course some of them overlap, sometimes from different directions. So to begin with, the points made by Mr. Campbell-Bannerman, I think, was the first speaker, which again, Chair, you also addressed this point, and the Commission as well. What would one do if a trading partner just said no? And probably many people, if not everybody here, will be aware that in 1990, in fact it was referred to, that in 1997 Australia and New Zealand both said no. Human rights don't belong in trade agreements. And with the current government in Australia, and yes, I am an Australian, that position is likely to be continued, I think we could safely say. I can't answer that question, obviously. But I could say two things that might have a bearing on this. The first is that one way that, to put it in the Chair's language, how could this be sold to recalcitrant countries if one wanted to sell it, which is a separate question. And I don't take a position on this. These were not my instructions in writing this report. One way of selling it would be to say, we are only talking about obligations that bind you anyway. So what we are adding is an enforcement mechanism, but we are not adding new obligations. And so the example that Mr. Campbell-Bannerman mentioned, which is Japan on being concerned with capital punishment, wouldn't arise in that case because, as everybody knows, there is no international rule against capital punishment. That's perfectly fine. You can have capital punishment if you want, provided you sign the appropriate reservations of the appropriate treaties if you sign up to them and so on. So that would be one way of softening that sort of objection. Now, having said that, the existing essential elements clause, in my view, actually does go beyond the situation in customary international law, and I need to say that the Commission has traditionally said that it is only a reflection of customary international law. My view is that that's actually not the case, for a very simple reason. I don't believe that the Universal Declaration on Human Rights reflects in full customary international law, and yet that is incorporated by reference into the Essential Elements Clause, and that's even more the case when one talks about democratic principles. The Charter of Paris, for instance, doesn't represent customary international law, nor is it in any serious sense a binding obligation in its own terms. So by incorporating these standards into a binding obligation, you upgrade them. So that is something, if one were to take this devil's advocate point of view, although I'm sure Mr. Campbell-Bannerman wouldn't see himself as a devil's advocate in this respect, however one might want to describe it, this is a point of interest, I think, and I think it would be maybe that's where there is some flexibility. No? Just tell the countries that they're not actually signing up to anything new. And in that respect, I like the Korea clause because it is an indication that what is binding under this clause is what is already binding anyway, so there's nothing new. Now, that is not to underemphasize the change that comes about when you have a new enforcement mechanism. That's, of course, still important because, as we know, human rights are not usually enforceable, and there is a question about whether countries would sign up to human rights obligations with a stronger enforcement mechanism. No? One can't assume that the substance is divorced from the procedure. That itself is a difficult question. Should trade agreements more generally, again a policy point, no? If not a philosophical point, should they be linked to human rights obligations? Well, here I would say something direct, which is there are two ways of looking at the connection between human rights and trade. One way is that you use these agreements, like you use the GSP, for example, as a sort of stick and carrot, no? Where the countries get benefits, or they get money in some cases, and then you take it away in the case they violate human rights. Now, there's a legitimate policy question about whether that's a good thing to do. But I would and I can't give you an answer on that. That's a political question. But that should be distinguished from the situation where the policy itself, in this case the trade policy itself, has a negative human rights effect. And I think there the tie is much closer. No? And if one treats human rights as an interest, then one can't have one policy on the one hand which undermines this other policy on the other, which is that you don't violate human rights. So I would distinguish these two types of linkage. One is a sanctions linkage, essentially, and the other is where the two are necessarily bound up because you're only talking about making sure that your policy itself doesn't undermine human rights. And maybe that's an area where there could be more flexibility as well. And that's what I was focusing on in this report when I talk about implementation. I think that can be a separate approach from a sanctions approach. And traditionally, as I said, the human rights clause has been seen in sanctions terms. It may be that as it evolves, the focus is more on implementation rather than sanctions. Now, the second major point I would make in this connection is that the situation of the EU is such, legally speaking, in my view, that one doesn't actually have the degree of flexibility that Mr. Campbell-Bannerman indicated. It may very well be, I think at this point it was Lord Dartmouth. It may very well be that EU member states didn't want to sign up to binding human rights obligations in the Treaty on European Union, in particular human rights obligations that apply to other countries. But in my view, that's exactly what they did. And of course, as an international lawyer, I mean, the first thing I ever tell negotiators when I advise them is don't think that you control the treaty. The words control the treaty, so you should hire people like me, basically, to make sure that the treaty doesn't say something that you don't want. In my view, Article 23, paragraph 3, subparagraph 1 of the Treaty on European Union is really pretty clear on this point. Now, if anyone's interested, I've recently written something on this. No one, to my knowledge, has made quite as much of an effort to talk about this provision. I'm happy to send and distribute this to anybody who's interested, but I'll just read it out because I think it's been a bit underemphasized. It says, the Union shall respect the principles, I'm deleting irrelevant bits, set out in paragraph 1, which includes respect for the indivisibility of human rights in the development and implementation of the different areas of the Union's external action covered by this title, which is all external action, not just CFSP, and Part 5 of the Treaty on the Functioning of the European Union, which includes trade and so on, and of the external aspects of its other policies, which means, if you take it all together, everything, no? And shall respect these principles is pretty clear, I think. So it's not a choice. No? The European Union has to make sure that its policies, when implemented, do not violate human rights, either at home or, according to this provision, abroad. So I don't think there is that flexibility. Now, whether one actually needs a human rights clause to make sure that this happens, there may be other ways of getting it through, but it's certainly a very useful mechanism for making sure that the EU's trade policies don't violate these other norms, so that the EU can protect itself, so that it can comply with its own self-imposed, maybe unwittingly, I don't know, but self-imposed human rights obligations in that provision. Another question from Lord Dartmouth was, what should the Parliament do? I'm assuming that the Parliament has this human rights interest. I confess I am speaking historically. The Parliament has had this human rights interest, and it may be, of course, that the Parliament changes its mind. Again, my instructions in writing this report were very much focused on how can the clause be used to enhance the protection of human rights in trade agreements. So that was my direction. Personally, I'm a lawyer. Obviously, I'm neutral. I don't take a position. But that's just to explain that aspect of the report. I leave politics and even policies to others. It's not my job. A question, who is civil society? Well, of course, yes, trade unions. I mean, we know civil society is often code for trade unions. If we're talking about labour rights, that I don't think is a problem. I mean, that seems logical, but it doesn't have to be only unions. I mean, why not human rights organisations? And there are plenty of them, from Amnesty onward. So I would see that any organised group with an interest in human rights would be encompassed by that term. Moving on to Mr. Martin, who emphasises the importance of monitoring. And yes, that is the main emphasis, I think, of this report. It is absolutely true that the Parliament has focused for many years on making sure that all agreements have human rights clauses in them. But there is an irony in this. And if one looks into the history of the Parliament's human rights actions before the human rights clause policy was adopted in the mid-1990s, one sees that the Parliament actually acted much more concretely with third countries insisting that they comply with human rights. So the irony is that by promoting a human rights clause, it actually leaves the stage to the Council on Commission proposal. And that is why reintroducing the Parliament, according to the proposals that I make here, is important. In a historical sense, it takes the Parliament back to an early 90s position, if this, of course, is what the Parliament wants to do. No one knows the mind of the future Parliament. Specific question on whether one of the enforcement systems that I recommend, which is individual action to trigger an investigation, whether this has worked in the US experience. I actually have examples of this in two cases, one to do with Bahrain recently, and the other, I think, if I remember correctly, was Peru. There are other examples. There's a recent study that's been conducted by the ILO on the implementation of these clauses, which I drew on. I think I have the reference in footnote 47, and I drew on this study in this respect. It seems that there are, in fact, there is evidence that it has worked. Not perfect, of course, and anyone who's familiar with these clauses knows that for many years they were held up as being a bit of a waste of time. But that doesn't seem to be the case in the long perspective. So there is evidence that they can actually work. Examples of problems, human rights problems arising out of the implementation of trade agreements. Again, a question from Mr. Martin. Well, a well-known example would be the HIV/AIDS drugs scandal as a result of high intellectual property protection TRIPS in that particular case, although as it actually happened, it was more to do that issue arose mainly in the context of South Africa's own constitution. But the discussion was to do with whether TRIPS, intellectual property protections, would prevent a country from complying with its obligations in relation to the right to health, that basically the drugs are too expensive. No? So essential medicines is one issue, and this keeps on coming up, more recently in the context of data exclusivity and so on. In India, I know this is a big issue, and so on. Whether these are real problems, I don't know. The point is not that the Human Rights Clause needs to be activated in these cases, it's that it can be activated if there is a real problem. I wouldn't want to assume that any trade or intellectual property obligation necessarily equates to a violation of human rights. This is simply saying you need a safety valve in the event that it does, which may never happen. Another example, which will remind me of a point to answer later on, raised by the Commission. Just with pure trade obligations, you can also have human rights problems. An example people don't always think of is if you encourage trade by liberalizing trade, you encourage exports from another country, one has to look very much at how those exports are produced. Now, of course, everyone here will be familiar with a simple case, which would be exports from the occupied territories. Another case with which everybody would be familiar, where the Parliament acted, is exports from Uzbekistan involving cotton produced in violation of child labour norms. The reason that protocol wasn't agreed by the Parliament was simply if we encourage exports from Uzbekistan, we also encourage further violations of child labour norms. Similarly, this arises in the context of land grabbing, displacement of indigenous peoples, not so much indigenous peoples, but just residents in or ex-residents in Cambodia, where the issue at the moment is sugar, and so on. I mean, there are plenty of examples, and the NGOs do a good job of talking about this. Again, I'm not taking a position on whether or not all of these claims are factually made out. I don't know. All I can say is they are allegations. If there is a problem, I am saying this is the legal tool that can be used to resolve the problem. Mr. Schultz asked many excellent and detailed questions. One is on the modernization of the human rights standards. That, again, I think relates to what I said before about whether the essential elements clause should be confined to a reflection of existing human rights obligations or whether it should be expanded. The thrust of what I'm saying is that it should at least be expanded so that if there are further, more onerous human rights obligations, the essential elements clause does not lag behind. In some respects, the Universal Declaration goes beyond the law. In other respects, it lags behind. That's my main point on that. In terms of the adoption by the Council of appropriate measures, I hope I'm not wrong in saying this, I didn't come with this in my mind, I think that these are adopted by qualified majority voting, but I'm happy to be corrected if that's not correct. There is a particular regime under the Cotonou Agreement which also involves the member states who more or less delegate this power in a mixed agreement, which comes back to the Chair's point, to the Council, and I think in that it specifies that it's qualified majority voting. The ability to adopt appropriate measures is very clearly, to anyone who reads it, not an obligation. Now, that doesn't stop certain people saying this from time to time. There was, in fact, a case a couple of years ago, the case is called Mugrabi, where the case found its way all the way to the European Court of Justice, which quite easily and obviously said, look at the clause, it's not an obligation, straightforward, it's a right, no? And it's a power that the Council possesses to exercise, clearly not an obligation. A very good point made by Mr. Schulz in response to my British colleagues, I think, which is that one has to look at this not only in terms of human rights imperialism, and I wouldn't deny that there is an element of that there, quite clearly there is. Maybe it's good imperialism, maybe not, but that's clearly an element from a political point of view. But also one needs to look at this as levelling the playing field in the interests of the EU. The same story was played out within the EU with the evolution of high environmental and labour standards. Countries which are rich and they have high standards, high level of human rights protection, they have corporate social responsibility and so on, one of their economic interests is making sure that poorer countries play the same game. So one can see this in more selfish economic terms as well as in more grandiose imperialist terms, if that's the sort of thing one wants to do. Mr. Moreira, in the chair, again, very good set of concrete points. The first I think I might have addressed, which is to do with what does one do with a strong partner, and then the very last question was what does one do with the United States? Well, I don't know, of course, what is to be done there. I have heard that
Neither do I.
No. So I can't say anything there, which I'm glad not to be able to say, really. Then some very interesting points, very detailed legal points to do with the competence, really, and legal basis for adopting measures under a human rights clause. And I addressed these to some extent in this paper. The specific point was, is this not common foreign and security policy? Now, why are we thinking of human rights in terms of what used to be first pillar? No, isn't this really what used to be third pillar? My answer there, and I addressed this on page 21, is no, it's actually not. And the reason is that all of this can be done under Article 207, which I assume everybody knows, of course, here. And the good recent example, actually, from the Commission mentioned is the Syria example, which is actually referenced in the report there on page 21, where there was indeed creative, very creative, use of a sort of we'd call it a sort of proto-human rights clause, to suspend an agreement with Syria based entirely on Article 207. So there was no suggestion that that needed to be done on the basis of common foreign and security policy. And of course 207 is a very flexible clause in many respects as well. There is more detail, it's on page 21, about the interrelationship of even the human rights powers in the Treaty on European Union and the common foreign and security policy. Now this is admittedly unsettled, but even if we saw this as not being the exercise of a trade power, but the exercise of a human rights power, as you can see on 21, There is an argument that this is perfectly possible legally in connection with the implied power in Article 352, and I go through this a bit on 21. So I don't think that competence problems really arise here, although it's not 100% settled, but I think it's close to being settled, and the practice is certainly in that direction as well. Another difficult legal question on the whether human rights clauses require treaties to be mixed. I mean, I am aware of the proposition that one of the reasons member states like human rights clauses is because it enables them to be involved with these agreements, and that keeps them mixed. It's been a while since I looked at mixed agreements. In fact, it's pre-Lisbon. I would say the situation has probably changed now, given Article 21 and Article 3.5 of the Treaty on European Union, potential soon accession to the European Convention on Human Rights. My view would be that it's likely, almost certain, that human rights clause does not itself require that the agreement be mixed from now on, even if, and I would agree with the Chair, this was the case prior to Lisbon, but Lisbon changed this radically. So I don't think that would be an argument for a mixed agreement. It would be what Alan Roses calls false mixity. Enforcement. Does this interfere with Article 218, paragraph 9, where the Council enforces? I actually, in an earlier draft of this, had an argument to the effect that it would even be possible to have a regulation under which the Parliament, assuming the regulation could be adopted through the normal procedure, but that assuming this could be done, it would not violate Article 218, paragraph 9, for the Parliament to have a role in the decision to suspend an agreement under 218.9. This is something that no doubt my friends in the Commission would disagree with. It's a complicated argument. I'm not going to make it here. It draws analogies with safeguard clauses, which is essentially the origin of the appropriate measures clause, and those don't seem to be a problem for 218, paragraph 9. The rationale, the logic is neither should this be. But I drew back from that in the final version of this study to a softer position, which is limited to the, let's say, the preparatory action before that decision is taken. So that question doesn't arise in this proposal because the decision to suspend is still a decision of the Council on the basis of a proposal by the Commission. That is all sacrosanct and protected. All that my proposal does is it talks about how does that Commission initiative come about. My idea is it comes about after an investigation which itself can be mandated under a regulation. I see no obstacle, no legal obstacle to a regulation that mandates the Commission to, or the EAS, whoever it may be, to commence an investigation into violations. Now that brings me directly to a point made by my friend from the Commission. Does the system currently work? Well, yes, it's of course true that there are cases where the GSP regulation, preferences under the GSP regulation have been suspended on the basis of, or at least taking into account, representations made by civil society and so on. But of course it is equally well known that there are situations in which nothing has happened and the Commission has refused to commence an investigation. I think the Chair referred to one with Sri Lanka. An ongoing debate, which is no secret in this committee, is Cambodia. I don't want to say too much about that, but I know...
And child labour against Pakistan in the 90s.
So, there are obviously examples where the Commission, how can I put this, has not taken up the invitation to launch an investigation on various grounds, and the EAS has supported this. That's what I would say on those points. The investigation itself can put, how can I put this? Well, bluntly, it puts pressure for action. If once the investigation is launched, that itself is something important. So finally then some other points by the Commission. Benchmarks. I was really responding there to previous statements in parliamentary resolutions. I tried to gather as much of the Parliament's previous practice and interest as I could and see how they would be fitted into let's say, enhanced, updated, fully enzymed human rights clause, would the benchmarks need to be reciprocal? I'm not sure that they would. I mean, there is an example already where the benchmarks exist and they're not reciprocal, and the European Union is not always in a weak position. And the obvious example is what happened with Colombia, where there were essentially benchmarks given to Colombia. Now, the difficulty there, of course, is that they were non-binding. So if one were to have benchmarks put in a side agreement which could then be linked to the essential elements clause and action under a non-execution clause, I think that is possible without this being necessarily reciprocal. But, of course, what the Commission says is absolutely right. It depends on negotiation. It depends on the relative bargaining power. I would not, it's not my role, but one would have to hesitate to write up a policy which said there will always be benchmarks. All I was saying here is that if there were to be benchmarks in any given situation, it would be better not to have it in the agreement as was proposed at one point by the Parliament, but rather in a side agreement which is of lesser duration. Not even an annex, I would say a different agreement, which would then be cross-referenced. On CSR, it's a very interesting point. Of course, traditionally CSR is voluntary, but there, as the Commission will know, there are examples where there are binding obligations, although of a relatively soft kind, but binding in the sense of addressed to the parties to the agreement, already in European Union trade agreements, for instance, in the CARIFORUM agreement. So what I'm proposing here is not really novel. It's actually there, and it's an EU achievement. In fact, the EU is in advance of most other countries in doing this. That is not maybe the mandatory voluntary distinction. I think that ship has sailed, really. It's already been done. I was working mainly on how the clause could be written, or how a CSR clause could be written to maximize its objectives, because I have to confess the Parliament, if I may be permitted to say this, the Parliament's resolution of 2010 on CSR takes a little bit of unpicking to work out exactly what the point of CSR being in trade agreements would be. And this is not just because there are conflicting interests, which is, of course, the case often in resolutions, but because some of those objectives don't really follow from a CSR provision in its current form. So my suggestions here were really to try and come up with a CSR clause that is in a different form that would correspond to those various interests, including the level playing field interest, which should be of interest to anybody here, because that's of economic interest to the European Union. To put it bluntly, CSR clauses don't necessarily, as they currently exist, don't necessarily do what people think they do. No? They need a bit of tweaking to achieve that result. On the effectiveness of the clause, the trigger mechanism, I'm grateful to have my words quoted back at me. That hasn't happened to me before, but thank you for that. It was a nice experience. Yes, I did say it's true that the clause is effective in the way that it is written, for sure. But what this study talks about is not that. What this study talks about is how to make sure that the clause is operationalized, not whether the clause can be activated in this wide range of cases. I think it can, and I think it's notable that it has been only activated in a very, very small subset of cases in which it could be activated. What I'm talking about in this study is what concrete steps can be taken so that the clause actually means something in practice. And on that point, I think it's quite clear to everyone that the clause is not effective. It could be effective. I think the essential elements clause could survive the way it is. The points I make there are optional. They're not necessary. Things can always be improved. But what really does need to be improved, if one accepts the premise that human rights clauses should be made more effective, is the provisions on implementation and enforcement. The final point by the Commission had to do with human rights committees and the extent to which human rights issues can already be discussed. Again, the Commission is, of course, completely accurate. The existing joint councils have a wide-ranging mandate to discuss everything, and also it is necessary to say that some agreements Jordan, I think, has this. Vietnam has this. There are a few. Have human rights subcommittees established under them, but this is done on a post hoc basis by decision of the Joint Council or Association Council or whatever it happens to be. So, and this is in the study, I'm not denying that this can happen. My point is that this is not a standing item which should happen. And again, I would say the fact that human rights committees have been created by joint councils in the past supports the idea that there's nothing inherently wrong, there's nothing that this would violate in the architecture of the agreement. It's been done, again, by the European Union. Why not just do it as a standing item in every agreement and foreground this it shows that the human rights clause is a topic of great interest. I remember now that I forgot a final question by Mr. Schulz. When I say that the civil society mechanisms set up in the Colombia Agreement are weaker than those set up in other agreements, which I say in page 10 and 11. Yes, I mentioned it very briefly. I analysed this at some length, actually, in another study where I was one of the authors specifically on the Colombia, Peru and Central America agreements, where I go in some detail into the relative mandates and powers of civil society mechanisms. This was just a shortened form of this. Essentially, the point is that there are greater rights of initiative, greater rights to communicate with the Joint Council, receive information from the Joint Council, status of existence as opposed to being called randomly, and so on. So there's more detail in that other study on that point. But it's certainly true that civil society mechanisms are not equal in all of even the recent agreements concluded by the EU. That changes from time to time quite significantly. I hope I responded to all the questions. Thank you again very much.
Thank you very much indeed. One of the reasons I'm very much proud of chairing this committee is our capacity to have such high-level debates about serious issues. Thank you very much indeed. Let me remind you that I use my arguments as in a devil's role. So I feel very much satisfied that you were able to respond very strongly to a number of them. Others are less tractable, I would say. But the idea that after the Lisbon Treaty, human rights is part and parcel of all the external policies of the Union, not only of the common foreign policy, is a very strong argument indeed, which I do share with you. Thank you very much. Ladies and gentlemen, this is the end of our public meeting today. We will proceed with an in-camera meeting to deal with item 12. So let me ask you to leave the room, those who are not entitled to stay, as soon as possible, as swiftly as possible.